Hello friends, my name is Dan. This video is an update for suing Ron Kirkwood, VicPD badge number 414, and the City of Victoria for false arrest and false imprisonment. In March 2017, we had what's called a settlement conference. If you're not sure what that is, Google Settlement Conference BC. The settlement conference was conducted at the law courts in Victoria, British Columbia. This was probably the most unfair and biased settlement conference in the history of British Columbia. I didn't get to speak much, didn't have an opportunity to ask for evidence. There was a lot that was wrong with this settlement conference, but I'm going to leave that for another time in another video. At the settlement conference, Lindsay Nilsson, lawyer for Ron Kirkwood and the City of Victoria, argued that Ron Kirkwood cannot be named in his personal capacity and asked the judge for a hearing to make submissions to remove Ron Kirkwood as a named defendant, as well as to strike my claim in its entirety. The settlement conference ended with the judge ordering a submissions hearing for Ms. Nilsson's motion to dismiss my claim. That submissions hearing was in April 2017. At the hearing on a motion to dismiss my claim, impartiality prevailed. Ms. Nilsson told the judge that the police acted reasonably and acted as per their policy, and that my claim lacks merit, and that Ron Kirkwood was obligated to arrest me and was authorized by law to do so, as well as in the manner my arrest was carried out. I, however, argued that the police acted unreasonably, without grounds, and for improper purposes. I told the judge that I could prove, via audio recording, that Ron Kirkwood wrote false and misleading statements to Crown Counsel in order to corroborate with a witness, and that Ron Kirkwood obtained an unendorsed warrant for my arrest that was not authorized by law. I also referred to Justice Leslie Baldwin in her August 19, 2011 decision in the Halton, Ontario courts in R. versus Davidson, a criminal trial in which Justice Baldwin describes the arrest of the accused as, quote, contempt of cop, unquote. The judge agreed with me that the evidence I have could substantiate my claim and would have to be tried at trial. Ms. Nilsson then argued that Section 21, Subsection 2 of the BC Police Act provides qualified immunity to Ron Kirkwood, and that no action for damages lies against Ron Kirkwood, and that Ron Kirkwood should be removed as a named defendant in his personal capacity. The judge, however, pointed out to Ms. Nilsson that Section 21, Subsection 3, Article A of the BC Police Act does not provide qualified immunity to Ron Kirkwood, and that, due to the evidence of the audio recordings, Ron Kirkwood cannot be removed as a named defendant in his personal capacity in relation to the conduct that is the subject matter of action, being guilty of dishonesty, gross negligence, or malicious or willful misconduct, and that the evidence would have to be tried at trial. The motion to dismiss my claim was denied. We are going to trial in fall 2017 with Ron Kirkwood as a named defendant in his personal capacity for false arrest and false imprisonment.